speaker on IPR, early stage of IPR. And to tell about Dr.A. Venkata Satyanarayana garu, who has done MTech in engineering, mechanical, and PhD in energy systems, and he has got almost 17 years of teaching experience and 10 years of research experience, could be absolutely called as rich enough. And he has worked in India and in East Africa also. And I am the quite witnessing personality about his services contributed to the University of Gondar in Ethiopia. And besides the good number of articles, good number of publishing, and participations in the international, national seminars, and besides being a member of editorial review board member for a good number of journals, I really would like to emphasize Dr. A.V. Satyanarayana on his attitude and interest towards patents. And in his 17 years of teaching experience and 10 years of research experience, he has got 5 patents granted. I would like to emphasize here on that. It is not the 5 patents that are filed. It is not published. It is 5 patents that have been granted to him. And I can say that his total concentration and his total interest in the experimental and industrial design and product operation methods, and he is not putting it directly publishing in the paper, and he is trying to convert it as a patent. And now 5 are already got it, and he has applied for WIPO, that is PCT also he has applied. One patent was applied by him, and I think many more is online. I don't know how many are there in transit now. I can say only 5 are granted, because in transit are the secrets that might have not been told and exposed by Professor Sir. Sir, with this little, what call this one, because if at all I keep on telling about you, I'm sure that I'll have to speak more than you. So I would like to conclude the identification with a great honor. Now, without wasting time, I would like to request Dr. A. Venkata Satyanarayana garu to address our students. And sir, the forum is consisting of students as well as the faculty members also, sir. And to be very frank, this topic here is the early stage of operations of patents, maybe the fundamentals of patents, which will benefit to the students as well as faculty members. I'm sure that this will definitely get enlightened, and I request you to take up the session, sir. Thank you very much.
Thank you, sir. Thank you for the nice introduction, sir. It is my privilege to attend the function.
Sir, Satyanarayan, sir, your face is not visible, sir. Please.
Not visible, sir.
Yeah, now it is okay, sir. Now it is.
So,
yeah.
It is my privilege to attend the function, sir. I am very thankful to the management of ITAM, that is the Aditya Institute of Technology and Management. So that is a very good institute that is reputed the statewide and also the nationwide. So I am very happy to know that ITAM is organizing the AICTE programs throughout the year. So I am very congratulate to the team of ITAM. And also I'm very happy to share my experiences with you on this IPR topic. So, shall we proceed, sir?
Girish, sir?
Yes, sir. Yes, we can start.
You just respond. Thank you.
The screen is visible to you, sir?
Yes, sir. Screen is visible, and make sure, sir, from beginning you create the slide.
Yes, sir. And before, this is the topic given to me, that is the identifying the intellectual property component at the early stage of innovation. So the innovation patenting, that is very, very important for any academic institute and also to an individual. So AICTE, they made the research mandatory in all the academic institutes. For the existence of any academic institute, so the research is mandatory. So the research means many people, they are focusing either onto the publications or patents. So publications is one aspect of research. So for the past 2 decades, the faculty and institutes much focusing on the publications. They have published their articles in the Scopus Index journals, the ESIE journals, ESI journals, and also they are maintaining the good high H index. So this is a very good scenario in the part of the research. But now the trend is changed. So the government is also focusing much onto the projects and patents. So recently, I remember that is in the 2020 January in Bangalore, one conference was held that is under the name Indian Science Congress. So our Honorable Prime Minister Narendra Singh Modi Garu, he has attended the function as a chief guest. So at that time, he stated two important words, that is IPPP. That means the innovate, patent, produce, and prosper. Innovate, patent, produce, and prosper. So the innovation. So the innovation is very, very important component in the research field, rather we can say. And also further, he stated that make in India. So zero defect, zero effect. So with that, the good product is possible and also the patents are possible. The governments are also recently, they are focusing onto the patents, the patenting. The patenting that should be known by every individual and also by any organization. So far, the filing was patent was done by many commercial organizations or companies, but its involvement in the educational institute is very, very less. Later in the slide, we can see how many number of patents are filed by the educational institutes. So nowadays, the trend was changed. Many education institutes, they are giving the importance to the patents. So the survival in this competition is very, very important for any organization. So very soon, we will get the new education policy. Under this new education policy, so only the research institutes will be survived after 10 years. So in the coming 10 years, many organizations, they have to improve their component. So in the new education policy, they have given much importance to the patent. Either he may be the student, he may be the faculty, he may be any individual, and it may be any organization. So they can file their right. That is their right. So publication, once if it is published, you will not have any right over this. So the publication means that is public property. Anybody can use. But the intellectual property, that does not like that. So that is the intangible property. So nobody can touch the intellectual property. Without your permission, nobody can use. You will have the proprietorship. You will have the ownership over this patent. So I think this presentation may be useful for filing the patent. So whatever experiences I have, that I will share with you. Okay, right. So I'm very happy once again for contributing my experiences, and also I'm very happy to become the part of the ITAM family. So the first one we are seeing the differences, that is the tangible and intangible property. Tangible means so the person can touch. So anybody can touch and anybody can take away. So tangible. There is a car. Suppose you are owning the car. You kept the car in the shed. So chances are there for losing the car. The building is there. So without your permission, the illegal registration may happen. Nowadays, we are seeing. So you will not have the proper proprietorship over this tangible property. So nobody can take, anybody can take away. But if it is intangible, the intangible means it is not touchable. So nobody can touch your property. That is called the intellectual property. So the intellectual property cannot be touched by any other person without your permission. So either it may be the patent, it may be the design, it may be the copyright, or it may be the geographical indication. So these are all become the part of the intellectual property. So the intellectual property cannot be taken by any person. So that is your right, the ownership. So you will become prosper in the future once if the rights are given to you. So the rights are given throughout the. So few people may think this is the intellectual property, so that can be viable throughout the world. It is not like that. So the intellectual property will be given to a particular country. The rights you will get in a particular country. That is called the conventional country. So suppose you are filing the patent. If you are filing the patent, you will get the rights only in India. Suppose if you have filed the patent in Australia, you will get the rights only in Australia. So for that, the PCT application may be helpful. Suppose those are called the conventional countries. So I remember that is in the year 1883 under the Paris, that is called what we can say, that is agreement. In the Paris agreement, only 11 countries have signed under this. But nowadays, many countries, they have shown the interest and now it is went up to 193 countries. So with a single application, you can get the right in 193 countries. In 193 countries, that is called the PCT application. The normal application means you will get the patent only in that particular country. Suppose if you are applying in India, you will get the patent only in India. That is one thing. And here in the second slide, I am showing the types of the intellectual property. Just now we have discussed it. If you open the website, that is in India, you can refer all these things in the Indian website. That is the www.ipindia.nic.in. www.ip means the intellectual property. ipindia.nic.in. So I entered into this intellectual property, the IPR area, as a layman. In the beginning, I do not have any information about this, but I have the interest. So once I have applied under the normal patent, but at the time the patent office was told, no, it is better to approach the design office. So I approached the design office. So there, controller of just like in our institute, controller of examiner, there we will have the controller of patents. So they have given me some guidance how to file the patent and all these things. Later I learned. This is what my practical experience with the patent officers. Really, they will encourage an individual once if you have the interest. So you have the design, you have the patent, you have the trademark, you have the copyright, you have the geographical indication. So all these things put together, we can call that is as an intellectual property. That is the intellectual property. Okay. So as an academician, we have to focus only onto the patents and designs. As an academic, so you are in the, many of you are in the academic profession, either he may be the student or faculty or any education institute. So we have to focus on to the patent designs, especially the remaining, that is the trademark and the geographical indication, that is not comes and in my opinion, they may not comes under the individual research, rather I can say. So that is go to the commercial organization. So the patents and designs, now we have to focus. So if you refer your NRIF applications, so recently the accreditations are given. So either it may be the NBA accreditation, NAC accreditation. So you have few points for the patents and designs. So the design that is also considered as an intellectual property. So few designs, they have a little weightage. The patents also, they have a weightage in your accreditation. So I can say that the student or faculty, so it is better to learn how to file the patents and designs. That is my sincere suggestion to all the people. So now you can see the patent grants comparison with a few countries. So little statistics you can see here. So you can see throughout the world, the China, they are applying for the patents. The patent filing is very high in China. The numbers are also you are seeing. So out of 13 lakhs patents filed, 4 lakhs patents are granted. So you can see the ratio. So how many are filed, how many are granted. So there is one particular procedure is there for the patent grant, that is called the patent examination. So the patent examination is very, very critical. Anybody can file the patent, but getting the patent is difficult. Later we can see few more statistics. So out of all countries, the China is applying the patents more. Next comes to US. So in the United States also, the patenting statistics are like this. 6 lakhs patents are applied and 3 lakhs are granted. That is only in the year 2017. So these are all the statistics for the 2017. So the next one, you come to Japan. So in Japan, out of 3 lakhs, 1,99,000 are granted. Later, European patent, that is EPO. And after India, you can see India where it is. So in India, only 46 are filed in the year 2017. Now 12,000 are granted. So you can compare with the China and US and India. So a lot of opportunities are there in India buying the patents. So that should come only with the interest. So please do not give away your hand. Suppose in US, a small ball pin is there. So the ball pin, the design of the ball pin also can be patented. They will apply the patent office and they will get the patent. So the ball pin is there. The ball pin is there. The shape of the ball pin, they will change. They will apply for the patent. That's all. They will have the ownership. They will get the ownership. So, and again, not only in the industrial designs. So, if you can able to focus onto the design aspect, that is another part of the IPR. So, the statistics of the IPR designs are like this. So, the year to year, that is only the filings in India. So, from last 1 decade, in the 2008, if you see, only 6,400 designs are applied for the patent offices. Now, it is increased up to 12,000 of 12,000. So in the 10 years duration, you can see how much interest is inculcated among all the individuals in applying the patents. The next one is the patenting procedure, the patent processing status in India. You can see the last 5 years statistics are like this. So in the 2014-15, the number of patents filed. So there are few stages are there. One is called the patent filing. That is the first stage. The patent examination is the second stage. The patent grant is the third stage. So in the year 2018-19, the last bar chart, if you see, so 50,659 patents are filed in India. Patents. These are called the technology patents. Either it may be the method patent, process patent, or product patent. In the olden days, that is before 1970, we have the process patent. Suppose any new method we have introduced, new method, the new process. So over that process, you want to get the patent. If it is innovative, definitely you will get. Suppose if it is a product, so such type of product, suppose this is a Bluetooth. So this Bluetooth was developed. That is innovative design, rather innovative technology. So you can apply for the patent. So likely in the before 1970, the process patents are there. Now all these things put together, they are calling it is as the product patent. Rather, we can call simply patent. Simply patent. So one more difference I will tell. So in India, we will call it is as the patent and design. Suppose if you go to United States, there they will call it is as the technology patent. They will call it is as the design patent. They will call the technology patent. They will call the design patent. But whereas in India, the wording is different. They will call it is as the patent, and they will call the design registration as the design, like that, patents and designs. So we need to focus over this. That is one part. So you can see the statistics, the designs are this much. Now, the patents filed are 50,659. That is in the year 2018-19. And again, under the examination, 85,000 patents are there. So, and also the patents grant, that is 15,283. You can see the patent examination, the number of applications are there for the examination. You can see the 85,436 applications are there under pending. Normally, the patent examination takes longer time. So it may take 3 years or 4 years for the patent examination. So in recent times, I heard that many patent officers, they have recruited the examiners. So within 3 years or 4 years, you will get the examination report. So they will make a search throughout the country, throughout the world. Rather, you can say throughout the world, they will make the search. So based on this, they will generate the examination report. So we have to give the answers. So basically, if they satisfy, then only the patents will be granted. So the number of the granted patents, you can see, that is 15,283. So the filed applications are this much. So from the last 3 years, 4 years, 5 years, I have seen few applications. So these applications are under the examination, which are filed in the year 2008 or 2009. Since last 10 years, they are in the examination. Suppose if they couldn't able to satisfy the constraints of the patent officers, you will not be given the patent. So the granted patents are very, very less. So once if they feel the innovative, once if they feel that it is very obvious, then automatically you will be given the grant. So the granted applications are 15,283. That is in the year 2018-19. So the trend of IPR filing in India. So IPR means that is put together patents, designs, trademarks, and also the copyrights. The cinemas are there. So many times you can see the copyrights of this movie are sold to some other person. So the copyrights also comes under the IPR. So they have rights over this. That is also a part of the intellectual property, the trademark. So all these things put together, you can see the trend from 2011-12 to 2015-16. This is the trend. So not only Indians, the foreigners also can apply, non-residents also can apply for the patent in India. So the blue color indicates the number of residents applying for patents. The red color indicates, so those who have applied in the India patent offices coming from abroad. So from the abroad, even they can file the applications. Such applications are there, 15,670 in 15-16. Now, by the residents, the Indian residents, the number is 2,67,390. So both Indians, foreigners can apply for the patent. Suppose if you go to Australia, if you go to US, there you can also apply the patent. So conventional country, in any conventional country, you can apply for the patent. Throughout the world, now 193 countries are there under the WIPO, that is the World Intellectual Property Offices. In any office, you can apply the patent. once if you have filed PCT. So that is viable throughout the world. Only one application. But in that country you have to go, you have to pay the fees and you can file. You can file. Okay, that is the point. Now you can see the scenario of the patents filed by the educational institutes from the last 1 decade. So 2009 to 2019. So our Science and Technology Minister, Sri Harshavardhan Garu, recently he has given one report to the Rajya Sabha. So at that time, he has proposed these statistics. You can see the Indian Institute of Technology. These are the premier institutes in India. So the patents filed by IIT in the last 10 years are only 3,751. But the granted patents are 519. But the granted patents are, so 3,700 are applied. The granted patents are 519. So still there are few IITs which they do not have even a single patent. And also the MIT, National Institute of Technology, in the 10 years period, 2016, patents are filed, but only granted patents are 10 against their name. But the scenario is different with the CSIR, that is the Council of Industrial and Research. So they have filed 2413 patents, and the granted are very good in number. So 1917 patents are granted. DRDO, they filed 998, and the granted applications are 519. So from all the educational institutes throughout India for the last 1 decade, the number of applications filed are 25,200 and the granted patents are 5,089. This is the statistics on behalf of the educational institutes. So the governments, so we have all the abilities. The students, they have all abilities. They know many softwares. They can know the good lab. They have the good laboratories equal to IITs. Many educational institutes nowadays they have all the facilities. So why can't we use these facilities? So you can develop a product that will become the innovation. Automatically, your name will be renowned. So tomorrow you can sell your patent. So I cannot say. So if you can able to make it commercialized properly, you will become the owner of crores of money. No need to depend on others. You can provide the employment to many. So these are all the patent officers to submit your IPR. So there are for 4 regions, that is the northern region, southern region, eastern region, western region. For the 4 regions, 4 patent offices are there. One is called, these are the patents and designs. You can file to the Kolkata, Delhi office, Mumbai office and Chennai office. And also the trademarks. So the trademarks, suppose you can say the Videocon. So we will write the V symbol that is in the circle. That will become the trademark to the Videocon. Such type of trademarks you can file in these offices. Mumbai, Kolkata, Delhi, Chennai and Ahmedabad. Later, if you see the geographical indication can be filed only in Chennai Patent Office. So the patent information system, even you can get from these, that is RGNIITM and also Nagpur. If you see the website, they have mentioned one app, that is the patent information system. So through this, you can get the information. So these are the offices where you can file your patents. So now we have to focus on to the patents and designs. So this is our southern office for the southern India residents. The patents you can file in this. So this address is also available. And also you can see the Kolkata Patent Office. Why I have mentioned the Kolkata Patent Office specially means, suppose the technology, the patents are there. The patents, the south side people, they can apply to Chennai. And also the eastern side people, they can apply to, the northern side people, they can apply to Delhi. Western side, they can come to the Mumbai, like that. But designs are there. So in whatever, wherever we apply the design, automatically they will send once again the design to Kolkata. So the lot of time will be wasted. Instead of this, if you can able to apply directly to the Kolkata Patent Office, they will process your design applications, and the design rights will be given by them. So I can suggest one thing: if you want to apply the design, only you use the Kolkata Patent Office. So the process will be handled by them very fast. That is my sincere suggestion to you. And also the period of protection. So suppose the innovation is there, so this is not the lifetime lifetime protection. So a particular duration, the rights will be given to you. Once, if the time is crossed, that will become the public property. So you will not have any right over this. That is called the period of protection. Suppose if it is a patent, the patent that is called the technology patent, rather we can say in US that is called the technology patent. In India, we will call this is a simply patent. So 20 years. The period of protection maximum that is 20 years. 20 years. Suppose for each and every year, either he may be the individual. Suppose you have applied for the patent, the examination was finished, you were given the grant. After that, so on your name for the 20 years period, that patent will be there. So in order to give the rights to you for this duration, you have to pay some fees to the government. For an individual, the fees will be very, very nominal. It may be 2,000 rupees or 3,000 rupees per year. So after the 10 years, it may be 5,000 rupees. All this, the fee structure in the schedule, the fee schedule, it was given by the patent office. So for the 20 years period, we have to pay the nominal fee to the patent offices. So every year they have to pay. That is called the renewal. Recently, I approached the patent office. I too have paid the renewal fee. That is 5,300 rupees, like this. So year to year, they will increase the fees very nominal. And again, the trademark. So the trademark will be valid for throughout the lifetime. So the period is for 10 years. The renewal fee you have to pay for every 10 years. You have to pay the fee. The patent is there. Every 1 year you have to pay the fee for the granted patent. The design is there. The design is valid for 15 years. So normally they will give for 10 years. If you want to extend 5 more years, the period they will give on submitting a separate application. The copyrights that is valid for 60 years. The copyrights are valid for 60 years. The geographical indication that is also valid for the throughout life. So you can see these are the period of protection for various intellectual property. So now we are focusing on to the patents and designs. So patents are valid for 20 years. The designs are valid for 15 years. Afterwards, that will become the public property. You will not have any right over this. If you want to commercialize within this time, you have to make it. Otherwise, it will become the public property. So the IPR differences. Now we are seeing the IPR differences. The IPR means, just now we have seen, there is a patent, there is a design, there is a copyright, there is a trademark. All these things put together, that is called IPR. So here we can see what is that? The first one is the fan. You can see the fan. The fan technology, it was there. So you have the electrical switch. If you give the power, the fan will be rotated. So if the fan is rotated, the fan blades also will be rotated. If the fan blades are rotated, so the air will be supplied uniformly throughout the room. That is what the application of the fan. Okay. So you have introduced some new technology. So electrical supply is minimum. The electrical supply is reduced. For the same effect you have used. Yeah, that will become the innovation. So that is the method you have applied. You have shown by using that method, the fan that was running very fast with the same power supply, that will become the patent. Suppose the fan design you change. So that is called the aerofoil shaped blades. You keep aerofoil shaped blades. Normally the people with the engineering background, they know the aerofoil shaped blades, not flat blades. aerofoil shaped blades you use, automatically the efficiency will be increased. That is, so if you change the design, that will become the design patent. If you change the methodology, if you introduce the new product, then that will become the technology patent. Rather, we can say that is the major difference between these. So the design means that gives the profile, that gives the shape, that gives the configuration. So separately that is design, that is called the industrial design. The patent means the method you introduce. You develop the new product that will become the patent. That is the major difference between these. The design will not involve any technological issues, but the patent always that is include with many technological things. That is what we can say in brief. So the next one is a trademark. So besides, you can see on the phone, mobile, one trademark is there. So that is just like an Apple they have kept. So I think that is belongs to the Apple phone. So they have used the trademark. So the trademark you can sell it. Recently, the Kingfisher Airlines, you can see the tragedy of the Kingfisher Airlines. But so the CMD, the Chief Managing Director of airlines, is Mr. Vijay Mallya. In those days, he sold his trademarks for few $1 billion. Suppose if it is recognized throughout the world, so it will have some brand value. That brand value usually you can sell under this trademark. The geographical indication. So the geographical indication, the chapels we are seeing at the lower side of this picture. So they have written the name Kolhari Chapel. So that was made in the Kolhapuri. So under the name of the location, they have prepared, they have made this innovation. That is why it is called the geographical indication. Tirupati Laddu. On the name of the Tirupati, the Laddu is made. So that is called the geographical indication. Kondapalli Bommalu. So in the place of Kondapalli, the toys are prepared. That will become the geographical indication. Like this. You can see the Coca-Cola bottle. In the Coca-Cola bottle also, all these you can see at a time. There is a patent, that is the industrial design, there is a trademark, there is a trade secret. All these things you can see. The Coca-Cola. So that is many, I didn't remember. So almost 1.9 billion people, they are consuming throughout the world this Coca-Cola under the various variants. So many variants are there. Suppose if it is Africa, that is called Africola. Suppose if it is India, we can call that is as a Pepsi and Coca-Cola. So actually that was introduced in the year, I remember, that is in the year 1886. In the 1886, the Coca-Cola was established in United States. Nowadays, the number of consumers are more than 1.3 billion. So the patents are filed by them are almost 550 patents are filed by them. So the Coca-Cola throughout the world, they have 550 patents on their name. Either it may be the technology patent or design patent. So like this, you can see these are all the few IPR. Later, in the single component, how can you make the differentiation? You can see the Coca-Cola bottle. So the first one is the logo. On the logo, it is mentioned Coca-Cola. So that has the brand value. So the brand value was registered in the patent office under the name trade secret. That is a trademark. Suppose the design that is called under the trademark. The next one is the design. The design is made like this. The bottle, you see the bottle, the appearance of the bottle is like this. The appearance of the bottle is like this. Suppose if you made the bottle in the spherical shell, the spherical space is there, you can able to store much liquid in it. That is become an advantage. Suppose if the shape is made like this, that will become the innovative design. So you can take the patent over this. So that is the meaning of the shape of the bottle. So that is nothing but the industrial design. So the next one is the bottling equipment. So now you come to the patent. Suppose the beverage company is there, or bottling company is there. So they will prepare this liquid, that is the Coca-Cola cool drink, by adding some variance. Suppose the variance percentage they change, then automatically the taste will be changed. So that is called the process. And finally, you will get the cool drink out. That is called the product. That is called the product. So you can apply, you can take this product into the liquid. So that will become the patent. If it is innovative, it will become the patent. That's all. That is the difference. The next one is the copyright. Suppose such type of patents, such type of Coca-Cola bottles are there. These Coca-Cola bottles, they have some database. They have some database. Here, copyright, whenever copyright is coming to my mind, one thing is coming. So many people with the computer science background, they thought that we have developed one program. We have developed one program. We have developed one software. Whether it is patentable. One thing I am saying that patent, that is the patent must be an innovative thing. It should have innovation. So the softwares or otherwise the apps or otherwise the programs, otherwise the course that cannot be patented in India. In India, you cannot take patents on this, but United States, that is different. In United States, you can approach the office for you have developed one program, the new program. Suppose if they feel that is innovative, they will give the patent. That is what the method, that is what the procedure they are following. But in India, we cannot take the patent for the programs. For the programs. That is one thing I want to keep for the information to many people. Okay. And again, you can see the ISRO, Indian Space Research Organization. That is a pride of India. So by seeing this, every Indian can feel pride, rather we can say. Okay, ISRO. So it was proved its importance in many areas. That is called the, I think they have used the satellite vehicles. They will take the satellite vehicles. These satellite vehicles, they will take it to the space. They will take into the space. So the ISRO, they are using the vehicles for the observing the Earth surface and also for taking the communication satellites, like this mini satellites. So all these things are carried by ISRO. So in Sriharikota, that is SHAR, it is abbreviated as SHAR, SHAR. So Vikram Sarabhai station is there, SHAR station is there. These are all working under the space technology, under the Ministry of Space and Technology. So that is named as ISRO. So many people, wherever we can say, we have the Abdul Kalam. So he is our former president of India. Vikram Sarabhai, he is also another great scientist. So both are originated from ISRO. So they are well known to all Indians. So under the guidance of Vikram Sarabhai and also our honorable former president Abdul Kalam Garu. So ISRO have got patents almost 270. So 270 number of patents they have, 270. Either it may be the technology patent or design patent. So the patents are 270 against their name. I have seen the statistics. In the 2017, they have one patent. After 2017, they do not have another. Now they are trying to, the few applications are there under the examination. I hope very soon they will get good number of patents. So far 270 against them. So the first was started in the year 1950s or like that, 1960s. So in this 50 years period, I think it was started in 1969. So for the past 50 years, so the number of patents granted to ISRO are 270. Copyrights are 45. The trademarks are 10. And here many students are there and a few faculty members are there. So I can suggest one thing. If it is possible, you please make a visit ISRO, that is SHART. So you please visit SHART Center. So they are giving the opportunities even to the academic institutes for making the mini rockets, the mini satellites. They are giving the provision. They will give the fund. You can apply for it. Not only for the patent, for the projects also, you can make a visit. That is my sincere suggestion to you. And also the another one is great innovation in those days. So 10 years back, so it was very popular in the Indian market. That is called the nano car, 1 lakh car. It was started by I think by Tata, by the Tata Group, the Tata Motors. They have introduced this in the year 2018. I remember that is called 1 lakh car. So this nano car nowadays, because of I think I cannot say some technological problems. So it is many people feel that is not safe. So due to some technological issues, eventually this nano car production was stopped. So it was stopped in 2018. So it was functioned from 2008 to 2018. So in the 10 years of duration, so they have applied for the 37 technology patents and 32 design patents. If you see the nano car over this, they will write 37 technology patents, 32 design patents like this. And you can see the industrial design. So now we will enter into our topic, that is the industrial design. So the industrial design, that is the protection to the profile, protection to the shape, protection to the configuration. Either it may be the 2-dimension or it may be the 3-dimension. You can have the right over this, as it is applicable to the industry, that is called the industrial design. That is called the industrial design. Suppose before me, the box is made like this. So you please change the shape of this box. So that will become the design. But the design should not present previously. Suppose if it is innovative, then only you will give in the registration. That is called the design registration. Any ornament, you can take the ornament. If it is innovative, you can apply for the patent. Suppose the fabrics, you take the fabrics. Suppose if you feel that fabrics was innovative, that was not developed by any other person, then you can apply for the patent. So physically, you should have a model. Physically, you should have a model. So you should have some dimensions. You should have some dimensions. So if it is innovative, the profile, the shape, they will give the right only on the shape. They will give right only on the shape. So please keep it in your mind. So you do not, there is no technology beyond this. There is no technology beyond this. Only based on the shape, based on the configuration, you will get the design if it is innovative. Then that is called the design of registration. That is called the design of registration. And here few things they mentioned about the design. So an industrial design constitutes the ornamental or aesthetic aspect of the article. That is what just now I said. That is the ornamental. That is made aesthetic aspect of any article. So here few examples are there. The chair is there. So you can see the automobile vehicle that is there. Suppose the mobile phone is there. The shape is made like this. Suppose the design was changed and it was used by the industry. Then it is called the industrial design. Either it may be the mechanical industry, or it may be the electrical industry, it may be the chemical industry, whatever it may be, it should be useful to all the industries. Then it is called the industrial design. It may be the 2-dimension object, or it may be the 3-dimension object. So the last, they have mentioned one thing, that is the 2-dimensional features, such as the ornamentation, patterns, lines, or the color of product. That is one, the design. So here, as part of my practical experience, I want to show one thing. This is the wind thermal accumulator. It was designed. There is nothing. So there is a multiple nozzle system. The purpose of the nozzle, you know. The purpose of the nozzle, you know. So that is used to increase the kinetic energy. The function of the technically, if you want to speak, so at the inlet, the pressure is high. At the outlet, the pressure will become decreased. The drop in pressure is used to increase the velocity. The nozzle is used to increase the velocity. Why should we use nozzle? So here, multiple nozzles are made. So in this picture, we are seeing 1, 2, 3, 4, 5, 6 number of nozzles we are seeing. So all the nozzle set. So here in the fourth picture, you can see that is the perspective view. You can see the perspective view. So all these nozzles put together, that is kept inside one casing. So this is the entire system is named as wind thermal accumulator. That is nothing but that converts that can able to convert the wind's heat energy. That is what the meaning of this thermal accumulator in brief. So I'm speaking only with respect to the design. So such type of design was made. You have to approach the office. That is called the representation sheet. You have to prepare one representation sheet. So the object should be made physically. That should be available physically. That should be available physically. So that object, you can take an item, what you have prepared, that you can take in different views. That is called in engineering, we can call this is as the front view. If you see the object in the front direction, that is called an elevation, rather that is called the front view. The same object, if you see in the top, that is called the top view. That is called, technically that is called the plan. The top view is called the plan. Similarly, you can see the side view, the right side view, and also the left side view. Like that, you can have in engineering drawing, so many views are there in order to describe the object. Whether by using the front view, top view, side view, you can define an object. Similarly, physically, you will prepare one component. So that component, you will take the photographs in many ways. So you have to take the picture in the front view, top view, side view, and any other perspective view in any direction. That is called the perspective view. So such type of photographs you can take. So here such type of photographs are taken. Okay. So while preparing, so your design grant, I'm speaking with respect to the design grant. So at the basic level, the elementary level, there is nothing wrong to focus on to the design. Once if you get experience with this, later you can apply for the technology patent. So it is very easy. Many people feel that the design patenting is very, very difficult. Unknowingly, they will approach the patent attorneys, rather patent agents. I've seen few people, they are applying the patent officers. Sorry, patent agents. Those are called a patent attorney. So patent attorney, rather that is called the agencyship will be given by the government. That is called the patent office. They will conduct the few patent examinations. Those who are qualified in this, so those they are called the patent agents. Technically, they are called patent attorneys. So many people, they will approach these patent attorneys. So they will pay lakhs of rupees. Patent filing, the idea is yours. The idea is yours. The development is yours. But only their role is to apply the patent. So for applying the patent, they are charging thousands of rupees. So I can suggest, suppose if you can able to know all these rules, if you can able to go through the manual, which is available in the patent office, there is nothing wrong. If you can approach the patent agent, you can you can file the patent within the short time. That is an advantage. Okay, you can save the time, but suppose if you can able to apply if you can able to read the manual, so I can suggest all the people go through the website. and download the manual. Either it may be the design manual or patent manual. So it is abundantly available, the material. Suppose if you see, almost the number of sections are 162 sections are there in patents. Patent sections are 162. Section 1, Section 2, Section 3, like that they have written. Section 1, 1A, 1B, 1C, like this. So 162 sections are there. 1972 rules are there. So it is not possible to go through all, just at least a few for the patents and designs, how to file. So they have given the information sufficiently. So I suggest all the individuals, so you please go through the website, download the material, and you can approach on your own. So please do not waste your money. It may take 5 days, 10 days extra, but within 1 month, within 2 months, you can make the filing. That is what my sincere suggestion. Either it may be the patent or design. In industries, patent attorneys are there. Their role is like that. So every day they will be applying for patents. But as an individual, you have to give importance to even to your money also. So I can suggest there is nothing wrong if you approach the patent agents, but on your own, you please try to submit. That is what my suggestion. Okay. So here, this is called the representation sheet. In the while applying for the design, you have to prepare the representation sheet. So based on the representation sheet only, the registration will be given. One few suggestions I will give. So you have to take the photograph only in the space. So you can take the photograph, keeping it in the table, but you can edit it. The table you remove, then automatically that comes in the space. The background, it is better to made white color. I can suggest the white color, at least the light colors. And it should not have any names over this. So this design should not have any names. It should not have any names over this. So likely, so whenever the training session is provided at that time, because we are running the short of time, it is now, let me see the time, it is 3:30. Okay. So this is what the design. The representation sheet and form 1, both are important. So for the design submission, the form 1, the second one is the design. Whenever the time permits in the training session, we can learn it. Okay. And again, the another one is publications by the design patent journal. Once if it is filed, it will be published by the journal. That is called the design patent journal. So many industries are applying for the patents or designs, and it was published. In the middle, you can see at the time I was working in Sri Vidyaniketan Engineering College. So in my lab, one augmented power turbine, augmented power generator, it was developed and it was applied for the patent. So under the help of my student, Mr. Siraj, it was applied. Okay. The next one is the procedure for the design patent, design grant. Here the procedure they have mentioned. The form fee is only 1,000 rupees. If you have the 1,000 rupees, if you can take the DD, easily you can apply. No need to approach the presentations. Okay. So the procedure, but you should know, 87 pages manual is there. No need to read all, at least a few steps. The first one is the form 1. You prepare the form 1 and prepare. The second one is the representation sheet. You have to prepare the representation sheet properly. Suppose if your submission is correct, then they will give the certificate of registration. Otherwise, they will give some time. They will give the examination report. That examination report should be answered within 3 months. So within these 3 months, if you answered well, so if they satisfy, then they will give you the registration certificate. That is called the certificate of registration. That will be published in the Gazette, India Gazette also. That will be published. I am very happy on this occasion to say that a few designs were filed by ITAM, that is Aditya Institute of Technology and Management. I think recently I have gone through the journal. I think it was published from ITAM, under the name Cooling Cap. Under the name Cooling Cap, it was published. I think it was he's my friend, Professor Venugopal. I think he has applied for the patent for this. Okay. So I'm very happy to see even the contribution of ITAM in the patents. The documents filing for the registration are like this. Just now I said that is the Form 1, the first and second. The Form 1 and the representation sheet, those are essential. Those are essential. Suppose if you are approaching the advocate, the patent attorney, the Form 21, you have to fill it. You have to fill it. Suppose if you are applying on behalf of the MSME, the Ministry of Small Micro Enterprise, I think. So suppose if you are if you are applying patents under MSME, then you have to fill the form number 24. So these are all the applications needed for the design filing. After the grant, the certificate will be given like this. That is called the Certificate of Design Registration. So the rights will be given for 15 years, 10 years. After the expiry of 10 years, you can go for the extension. 5 more years they will give. The next one is the patent. So far we have discussed about the designs. The next one is the patent. The patent. I think in the beginning itself we have discussed a few things. That should be innovative. That should be innovative. That should be obvious. That should have the industrial applicability. Then automatically it will be given the patent. So that is granted by the government of India. That is granted by the government of India. So the inventor, so there actually two things are there. So one is called the inventor. The one is called the inventor. The first one is the applicant. So the applicant will become the owner of the patent. The innovator is the innovation or innovatorship, that is only the recognition. Suppose you are working in the company, so that was developed by one person, he will become the inventor. He will become the inventor. Suppose the name of the company, the organization, if it is mentioned against the applicant, he will become the owner of the patent. So along with the company, so in the applicant's name, the company can be there, and also the employee also can be there. Okay, then automatically the rights will come to you. That is the another point I want to bring to you. So these are all in the patent office. If you see their website, that is ipindia.nic.in. So there you can have all this information. So you can see patents, you can see designs, you can get all the manuals, they are available. And also the patent acts, these are all actually in the 1970, the patent act was developed. The patent act was developed in the year 1970. So 4 times it was amended. I remember that is in the 1999, in the year 2002, in the 2050, 2005, the patent acts were amended. They are amended. Now 2020, they are going for the amendment. So very soon you will get that information. So that is called the amendment 2020. The new education policy also, they are giving much preference over the patents. So here, what is patentable and what is not patentable? If you can able to make this differentiation properly, then you can file a patent on your own. So first you have to see whether it is patentable or not patentable. Even under the patent examination, so they will take the time for 3 to 4 years. Under these 3 years, they will make the search throughout the world. The patent examiner, so normally they will go for the US patent search. US patent search. In the US, almost all innovations are available. That is what their idea. Not only US, they will make the search throughout the world, but they will give the importance to US, United States. So the Google search is there, the patent to Google search, the patent to Google search. So in this, suppose if you type anything, whether it is available or not available, so easily you can get the information. Based on this prior information, you can apply for the patent. That is the criteria for the patentability is the novelty, that is the innovative step, and capable of the industrial application, and whether under the provision of the Patent Act of 1970 that falls or not. So they will see all these four things. That is called the novelty, innovative, industrial applicability. So which is patentable, which is not patentable. One thing just now in the beginning I said, that is the method can be patented, process can be patented, and also the process can be patented, or rather we can say that is the product can be patented. If you see the patent office, there are four divisions are there. One is called, so whatever may be the application, they will take into these four categories. The first one is called the biotechnology. The second one is called, I remember, the second one is called the chemical. And the third one is the electrical and electronics. And the fourth one is the mechanical. So their dynamic utilities, one column is there in the website. If you open it, you can see how many number of applications are there for the examinations. So whatever application is there, so only for these four categories they will consider. One is the biotechnology, that is the medicines, pharmaceuticals. The second one is the innovations. The second one is the chemical industry, the chemical composition you can vary. The third one is either it may be the electrical or electronics industry, and the fourth one is the mechanical industry. Like this, in all these four categories, the innovations are possible. This is what the methodology, the patent office, they follow. Okay, that is the another information to you. So you have to see which is patentable, not patentable. The speech, suppose if I am giving the speech, this speech is not patentable. The speeches are not patentable. The programs, course are not patentable. Patentable means the industrial application, innovative, obvious. So one more thing here, you can see the patent grant stages. The documentation is there. That is the documentation. So you have to file the patent. Let me see the time. Now it is okay. I will try to. We are running the short of time because the subject is very huge. So this period may not be sufficient, but we will try to learn few things. And the patent filing, the documentation of the new invention. So first you have to make the documentation. That is the, suppose you have the idea, but you have not developed in the, you have not completed that in the proper manner. The product was not developed, only the idea you have. So immediately you can write one application. I have this idea. There are few things are there how to prepare the document. That is called the provisional patent. You have an idea, but it is not materialized. The product was not developed. Then also you can apply because others cannot copy your idea. That is called the provisional application. Once, if it is fully completed, the work is fully completed, then you can apply under the complete specification. So after the submission of the provisional application, within 12 months, they will give the time period 1 year. So within 1 year, you have to apply it for the complete specification. Whenever the complete specification application is reached the office, then only the process will be started. If you are unable to submit the complete specification within 12 months, so you can say that is winded up. They have closed the application. So likely. So within 12 months, you have to submit the complete specification. Then automatically it will go for the examination. The patents are many. So there are called the utility patents. You can call that is as a utility patent. Many countries, the technology patent, that is called the utility patent. Suppose the technology is one, multiple inventions are there, that is called the divisional patent. That is called the divisional patent. One more thing is there, that is called the patent of addition. One more thing is there, that is called the patent of addition. So to the existing patent, suppose if any innovation was made to the existing patent, that is called the patent of addition. It is called the patent of addition. So you have the utility patents, you have the divisional patent, you have the patent of addition, and also similarly have the PCT application. In the beginning it was said PCT application, Patent Cooperation Treaty, that is comes under the WIPO, that is called the World Intellectual Property Office. So one patent application, that is sufficient. There is no need to prepare many. One application you prepare, whatever country you want. You go to that country, you pay the fee, you apply the application. Then you will get the grant. You will get the grant. So the WIPO, that is called the PCT. That is one. These are all called the types of patents. So either it is the complete specification or the provisional application. You have to decide. Idea is called the provisional application. So then the complete innovation, that is called the complete specification. So that is another point. That is called the documentation. So once if it is finished, the patent search for the validate information. So the patent examiners are there in various offices. So nowadays many examiners are there. They will make the search throughout the country, and if anything they identify which is similar to your innovation, then they will mention in the examination report. In the examination report, if in the examination report there is no such type of copying, there is no such type of plagiarism, then chances are there to get the grant. So the patent whenever now the time is not permit to show the examination report. Actually, I planned, but we will proceed. We will discuss the procedures whenever the time is available during the training sessions. We will make a practice. So the next one is the filing for a patent in the patent office, right? Next, publication of the application. Once if the patent is filed, then within 18 months that will be published. So that will be published means that is kept open to all the public. So if any people have objection over your innovation, then definitely immediately they have the right to bring to the notice of the officials of the patent office. So that objections will be considered. So one that is called the publication. That is every year one publication will be released by the patent office. Either it is a patent application or patent journal or design journal. So after this, the examination. So keeping the opinions of the public and also the examination done by the scrutiny done by the patent examiners, the report will be prepared. So that report will be sent to the person. So if the person, the inventor, applicant, he has to give the response. So the time limits are also there. Within the time restrictions, they have to give the response if they satisfy. So if they satisfy, then you will be given the grant. If they does not satisfy, one more opportunity they will give. That is called the hearing. So personally, you might have to visit the patent office. So then you will get, if they satisfy, then finally you will get the patent. So after the grant of patent, periodically you can go for it. Periodically, you have to renew your application by paying the patent fees. And again, this is the flowchart of patent. Just now I said how the patenting process in India. So that is called the filing of the application, either the complete specification or the provisional application you can file. The time for the publication is 18 months. That will be published in the patent journals. So we're taking the opinion of the people, taking the opinion of the examiners, the report will be prepared. That is called the examination report. That is called the first examination report. So the first examination report, the inventor has to respond for it. He has to respond for it. So if they did not satisfy with your response, then they may ask you to come for the hearing. So in the hearing, if they satisfy, then the grant will be given. That is called the decision. That is called the decision. So the publication, this is called the pre-grant opposition and a pre-grant opposition. After the publication, suppose if any public, they oppose it, so they can approach for the hearing, they can approach the patent officers, they will make the hearing sessions, then they will take the decisions. After taking the decisions, the grant will be given. So all applications which are filed may not be granted. So the procedure, it is very, very difficult. In the examination reports, so based on the examination reports, you have to respond. They have to convince, yes, this is innovative product. Yes, it is obvious. It is not existed so far. So that is what in the examination reports they mentioned. Suppose if it is copied, and if suppose in one document, either it may be the journal publication or it may be any other patent, if they found such type of copying, they will mention that plagiarism in the report. So in the hearing sessions, you have to prove in what way your innovation is different from others. If you can able to prove it, then only the grant will be given. That is why so many people they are applying the grants applications, but number of grants are very less. You can see even from IITs how many people they have applied and how many grants are given to them. It is nothing difficult. It is nothing difficult. Once if you have the confidence, then easily you can apply for the patent. You can prove yourself. So the confidence play an important role in the hearing. So based on the novelty, based on the inventive step, the grant will be given. The grant will be given. So that is what the patenting process. So the components of the complete specification. So the components of the complete specification. So the idea you will submit the provisional application. If you want to make it the complete specification, these items are mandatory. So that is the title of the invention. Just like your project report, you will prepare the project report. So similarly, if you can able to prepare, that will become the complete specification. The title of the invention, the objective of the invention, the field of the invention, what is the drawback with the existing art, what is the statement of the invention, what is the summary of the invention, and here one important step is there, that is called the drawings. That is called the drawings. So you have the product, you have to develop the drawings. There are certain procedures are there for drawing the drawings. So chances are there you can learn in the sessions how to make the drawings. And afterwards, we have to describe about the drawings. That is called the preferred embodiments. The detailed, so the brief description about the drawings you will mention here. The detailed description of these drawings you will mention in your application. Up to here, these are all the various components of the application. The last two things are there. The claims and drawings. These are also you have to submit. So the claims, the drafting of the claim is very, very important. Very, very important. Each and every point in the claim will be seen by the examiner. If they feel, so the total examination I can say. So I attended for the examinations, the hearing, the total examination is around the claims. If they feel that is innovative, so they will observe the applications very keen. That is why 4 years, 5 years time they will take for the examination. Really, they are doing the wonderful job. So if they feel that is innovative, each and every point in the claim will be given. Whatever rights you are taking, so what in the claims, one page will be there. So under the claims, whatever you have written, you will get the rights only over the claim. So drafting the claim is very, very important. Based on this, your patent will be granted. That is another suggestion to you. And again, the drawings. So there are a few standards are there, how to draw the drawings. So we have to keep all these things put together. That is called the complete specification. So this is my case study. So I have one idea. So while I'm studying the MTech level, I got that idea. Why can't we convert the AIDS, heat energy, into kinetic energy? So such type of multiple nozzle system, it was fabricated. So in our laboratory, I have the wind tunnel. The experiment can be done by using the wind tunnel. So the nozzle system that is attached to here, the heaters are kept at the end of the nozzle system. So by using the multiple nozzle system, the heat energy is converted into the kinetic energy. So it was proved that the atmospheric air will have some kinetic energy. So that kinetic energy, that heat energy, so atmospheric air will have the heat energy. That heat energy can be converted into the kinetic energy. Suppose if this nozzle system is there, the air is come with a more velocity. So easily that will rotate the wind turbine. Outside you have the wind turbines. So the wind turbines rotates at the higher RPM. So its efficiency will be increased. So we do not have sufficient time to discuss about this in detail. So this is one case study which I have dealt in past. So this is an experimental setup in my laboratory. So previously I worked with Polarity Engineering College. So in the G Polarity College, the laboratory, we have this experimental setup. Using this, the experimentation was done. So this is called the wind tunnel. That is called the wind tunnel. This is called the wind tunnel. This is a wind turbine. So the nozzle system was fixed here. So it was proved, yes, that can able to convert the heat energy into kinetic energy. So after the grant, you will give the applications like the government information like this. This is from the government of India. You will get the information. So you will get you have applied for the claim this, and you have given rights like this. So this is called the patent application. So the few things at the end, the geographical indication. So based upon the geography, I do not know much about the geographical indication because I did not deal so till now. So based on only one thing I know, based on the location, you will get the patent, just like the Tirupati Laddu, the Kolhapuri Chapel, the Agra Peta, like this. So based on the location, suppose if that is innovative, the group of people will get the geographical indication. So these are the trademarks. So these are all trademarks by few companies. That is the Yahoo, and these are all, they have the brand value. So once if the trademark is registered in the patent offices, so then you can sell its brand value. You can sell its brand value. That is what I know about the trademark. So this is purely commercial. The trademark that is purely commercial. Okay. So I think now the time is 4 o'clock. So I have the instructions that because many people have to leave, sir. That is why better to by 4 o'clock. That is why I tried to plan the time. So this is for the discussion. If any participant have the query, now they can open. They can.
Girish sir?
Yes, sir.
Yeah, anybody has questions? Can we start questions, or you will collect the questions and you can give it to the professor afterwards, so
Yes,
that can
sure.
be answered. I suppose we don't have time, in fact.
Hmm.
Yeah.
As per your convenience, sir. If you want to, if they want to meet physically, okay. If they want to send the questions
Girish,
by chat box also.
Girish sir,
Yes, sir.
can we continue?
Sir, we can ask the questions. Like we can record the questions, sir. I'll.
Yeah, absolutely. Yeah. So, shall we conclude the session?
Yes, sir.
Yeah, thank you very much, Professor Satyanarayan garu. Thanks for since the topic itself is the early stage of how the patents and a brief description about the types of the patents and how to fill the patent and the process of patenting and the time being taken while patenting, while granting the patent. And there are so many problems that you have come across, and your experiences have been narrated in a beautiful way with very good examples. Thank you very much. I am sure that this particular session has enlightened our students and faculty members to the extent of starting their patenting plans. And I'm sure that another session is highly needed, especially for the interested group, for the target group who are there in our college also, and they are all working on patenting. And definitely filing is one very important thing. Documentation of filing is one very important thing which we should absolutely learn, so that we can save money as well as file many cases. So I strongly feel that there are some inhibitions and step backs because of the investment problem. And if that is the problem, if they can learn, or if they learn how to document and how to write a document and how to file the case, I'm sure that it will be easy for them. Since I strongly feel that the innovation is harder than documentation. So I once again thank you for your highly intensified lecture, and which will definitely give an ideology of how patenting should be applied, should be filed, and should be granted. Thank you very much, sir. Thanks for your time, and thank you very much. Great, sir. You want to say? You can say something.
Thank you very much, sir. So
Thank
I'm
you.
very thankful to all the participants. I hope, so I will be happy if the information of this presentation is useful to you. So in future, it is not at all easy. So the patent filing. So on your own, you can do patenting. I wish you all the best for your future endeavors.
Thank you, sir. Thank you.
Thank you so
Very
much,
best.
sir.
Thank you,
Sir,
sir.
Satish sir ఏమైనా ఉన్నారా? గిరీష్ సార్, సతీష్ సార్ ఏమైనా ఉన్నారా?
He is not there, sir.
Okay. Shall we conclude then?
Yes.
Yeah,
Yes,
you
sir.
can conclude then. Thank you.
Thank you so much, sir. Thank you so much,
Thank you.
participants, for joining us. And you can listen to the video. You can listen to the lecture in the YouTube also, in the official ITAM official YouTube channel.
Thank you.
Thank you so much, guys. You can leave the session. You can leave the.
Thank you, sir.
Thank you, sir.